Good afternoon, dear guests, ladies and gentlemen. We're going to start off our conference on the essential state functions in platform regulation. And before I say any more, I want to ask our Deputy Director General, Mr. Péter Lánci, to come to the podium and deliver his welcoming words. Thank you.
Dear guests, friends, colleagues, I'm really happy to greet all of you here at Mathias Corvinus Collegium, or just as we call it, MCC, which is technically right now the largest extracurricular talent management institution in all over Hungary. And as a daily basis, what we are doing is that we try to find the most talented university students all over Hungary and try to make them a place where they can meet, where they can learn, and where they can become friends and make a community from each other. As such an institution where lawyers, economists, engineers, philosophers living together, such an institution per definition have to be interdisciplinary, like the conference we are facing today. Almost exactly 1 year ago, MCC Media Center organized an international conference on free speech. You may guess that the majority of the debates circled around the very topic of the online platforms, and especially from two aspects: how the online media platforms gain their revenues, and what should the government do with the increasing power of these online platforms. I think those who were there back at that time understood that this is not a very exotic topic of the media world, but this is very important, not just for today, but maybe the shaping of tomorrow. As an educational institution, our job is to give all the students the current knowledge which is available, and as well we have to equip them with the necessary skills and knowledge which may help them to be a good technical people of the next generation. Since our last conference in the regarding topic, we established a center for freedom of speech, a center for modern legal studies, and we already had a center for future technologies. So I'm quite convinced that MCC students are prepared for understand what is the nature of online platforms and why it should be necessary to understand them to shape to the future. My opinion about online platform regulation is just a fight against the hydra, that if you cut one hand, the two will grow instead of that. And if we look back to the Greek mythology, the answer of Heracles was that he was not able to kill at first the hydra, because he needed help. He needed help from Pallas Athene, and he needed help from his cousin, who was the carrier of the guns, and finally he competed the hydra. For me, if we can, I suggest for all of you to learn from the wisdom of the ancient Greeks, and we have to work together to find the good answers for platform regulation. So we have to understand, we have to have the equipments of the law to cut ahead. We have to understand the economic forces which shape how online platforms are just boosting up again and again. And also we have to talk about our ideas and experiences, and we have to share, we have to have a shared wisdom about this topic. I'm really hoping that during this conference, all of you will acquire some knowledge experience or understanding of this very interesting and very necessary topic, which I'm just going to repeat myself, will shape our future. So have a good way of understanding about the platform. So thank you very much.
Thank you, Deputy Director General, for your welcoming words. And as moderator for our plenary panel, it is my duty and also my pleasure to first introduce our speakers and then frame the panel a little bit, as well as address some questions that I've gotten over coffees. Why this title for the conference, Essential State Functions in Platform Regulation? So I also want to welcome our guests, our students, first and foremost, and those of you as well who might have been present at previous conferences that we had on the topic. None so far organized by the Law School and the Public Law Center, which I represent here. So we're trying to bring together all of these different professions today. As Mr. Lanzi has mentioned, lawyers and economists, or some lawyers and economists, will talk today and tomorrow about different approaches to platform regulation in the context of essential state functions. And to address the question briefly, why we're talking about essential state functions, I've participated in many conferences recently where the issue was the changing role of the state in the 21st century and in the online world in relation to disruptive technologies. And this brought to mind my earlier research that I did on constitutional identity. And the Treaty on the European Union, in its Article 4, Paragraph 2, contains a section on how the Union respects essential state functions. And I think that discourse today, with the problems that we face with the changing role of states and the increase of private regulators, we could say state actors even sometimes, they present a challenge where we should look at whether there are any essential state functions left in this field. If yes, what are these? And how do they relate, for example, the enumeration that is contained in the Treaty on the European Union, because it mentions national security and maintaining law and order as specific examples for essential state functions. But it's not an exhaustive list, so we can also ask the question, where does this list end? What are other essential state functions that we need to talk about? And obviously, we know functions like this in media and content regulation, in competition law and consumer protection, and also data protection and privacy. So we've chosen these fields for the different thematic panels to address the issue of platform regulation from these angles, because in all of these areas, we have multi-level regulation in Europe at this point, and we have to find ways and approaches how the national level regulation and the European level regulation can interact or blend in with each other, because that's what makes our life easier going forward. And maybe I want to address the problems or challenges that are brought about by the appearance of private regulators in parallel with state actors. How these change our concepts of essential state functions and what lies underneath them. Obviously, these processes that we've described before challenge preconceived notions of sovereignty, subsidiarity, debates about digital sovereignty appear, or how subsidiarity is characterized by the platforms themselves, simply due to the fact that they become the closest to the online community, and obviously they feel a natural drive how to solve problems that arise in those contexts. And across legal systems, we may look at these issues differently. So we invited here today and tomorrow experts from the United States and also from all over Europe to try and learn from each other in this sense. And I'm not going to say any more about the introductions. I just merely want to introduce our keynote speakers. Our first keynote speaker arrives from the front lines of law and economics, already an interdisciplinary approach. And he's bringing over a decade of public and private sector experience to his research and teaching which he does at George Mason University in Washington, D.C. Professor James Cooper, to the left right there, he served as the Deputy and Acting Director of the Federal Trade Commission's Office of Policy Planning, and he's been advisor to Federal Trade Commissioner William Kovacic, as well as an associate in the antitrust group of Cromwell and Moring LLP. Currently, he's the director of the Economics and Privacy Program at GMU, and his interest in privacy and how it relates to platform regulation and also many other fields, as we will soon see, is the main reason that we've invited him here today. The US approaches to privacy have long shaped European concepts of privacy in public and private law as well, and we are curious to see what are some current thoughts and tendencies in this respect that might inform our current European debates about platform regulation. And our second keynote speaker is from Hungary. He will focus on those current issues of media and content regulation that inform our daily debates and sometimes collisions with the EU and its legislation in this field. Dr. Balázs Bartóki Gönczy is a junior member of the Hungarian Media Council with his PhD on legal issues presented by online platforms. And he's graduated in law at Pázmány Péter Catholic University in Budapest. And also he's received his degrees in French law at the universities of Panthéon-Assas, Paris II, and Paris-Saclay, where he specialized in telecommunications and space law, two of the final frontiers of today's technological world. And in addition to this, he has also obtained an MBA from Lyon 3. So I give them a nice round of applause. And Professor Cooper, you have the floor.
Oh, great. Thank you. And this is dummy proof, giant buttons. So even I can't mess this up. Thank you so much for the kind introduction. It's great to be here. It's fantastic to be in Budapest. I told Márton that I had been here back in 1995 as a graduate student. I was getting my PhD in economics, and I came here with my best friend doing what Americans do, getting the Eurail pass and coming around. And I remember remember Hungary and remember Budapest fondly. It's great to be back here, not as a poor graduate student staying in a hostel, but being treated very kindly and getting a real hotel room and free coffee, something I couldn't have gotten before. I also mentioned when I was an undergraduate, I had actually studied Eastern European economics. I was an international relations and economics major. And I actually focused a lot on Hungary at the time, too, because Hungary was kind of in the forefront of, in Soviet economics, or in Soviet economies, at least, in the reform. Unfortunately, by the time I graduated, all that was irrelevant because the Soviet Union had fallen and capitalism was taking root. So good, very good for Hungary and for the people of Eastern Europe, not so good for my 4 years of education. But nonetheless, it is truly my honor to be here, and I'm glad to talk about the U.S., kind of a broad overview of areas as mentioned in the introduction. I'm a professor of law. I have a lot of experience at the FTC. I've done competition law and consumer protection law, and have recently focused my academic work a lot on privacy, and in particular the economics of privacy, which is the center that I run at George Mason, Anton Scalia Law School, is called the Program on Economics and Privacy, where we have conferences and sort of develop academic research in the area. And I've never, however, as much as I love our conferences, I don't think I have ever put one on in a forum as cool as this, Windows Coffee Shop. I love it. This is great. So what am I going to talk about today? I'm going to talk a little bit about privacy regulation, and then talk about something that's kind of special, but unique to the United States, the First Amendment, which is in our Constitution, and it limits information regulation, which is different than kind of, I think, can't be overstated, the difference between the ability in the U.S. to regulate information as opposed to Europe, where actually in the United States we have no constitutional right to privacy, but there is a constitutional right to the free flow of information. So I'll talk a little bit about content moderation at the end of the talk, and I'm going to talk a lot about the role of competition. So let me get started. Let me talk about privacy. So the bulk of my talk is going to be about privacy regulation. How do we think about privacy in, so privacy is really about control over the information, about the party having control over information. So you see my beautiful stick figure there drawing on the left side. There are lots of things that you know about yourself. Your birth, something as innocuous as your birth date and your gender, but then things that are a lot more sensitive. And the question of privacy is the information flow and who controls it. If there's a counterparty over there, do you as the person have the control to reveal anything there in the green box? That's up to you. That's what we mean by the right to privacy. But then on the other hand, do you as the counterparty who may want to know, do you have a right to pry? I'm using these terms. There's a famous law review article by Richard Posner, a judge on the Seventh Circuit, very famous founder of law and economics. He actually wrote a famous law review article in the 1980s about kind of looking at privacy as the right to privacy versus the right to pry. If there is a right to privacy, then do you as the counterparty over there have a right to actually pry to find that information? And why is that? Well, because there are trade-offs in these. If we retard these information flows and we cut off these information flows, it can have impacts on private impacts, and it can have social impacts, and it has to do with goods and services markets, employer-employee markets, lender and borrowers. So all of these markets can be impacted when when private information about individuals is not flowing, right? And there are privacy benefits, but there are privacy costs. And this is how we think about this, at least as an economist studying privacy, is what are the benefits from privacy first? Well, clearly, again, with my economics hat on, and those of you who study economics, as economists, we talk about utility. Every consumer has a utility function, and we try to maximize utility. And so clearly, we as humans get direct utility from privacy. We all value privacy. So there are direct utility benefits. There are also what we call dynamic benefits from privacy. Again, it's about fostering incentives to take productive actions. What do I mean by that? I'll give you an example. Again, from U.S. law, I don't know if they have the same counterpart in EU or Hungarian law. Something we have, the doctor-patient privilege. So anything that you tell your doctor, the doctor is not allowed to reveal that. Okay, that is a law. You still control, that's privacy, right? You're revealing information to them, but you still actually control the flow of that information. You retain control over it. The doctor cannot reveal it except in very, very narrow circumstances. So, for instance, if you tell your psychiatrist that you're about to go kill somebody, well, the psychiatrist has to reveal that. But other than that, these things are held sacred. Why do we want to do that? Well, you want to create incentives. If it were the other way around, if doctors were actually allowed to set up, a Facebook page where they told all of their most embarrassing stories of the day. Could you, let me tell you what I heard today of these strange conditions. Then you could imagine your willingness to provide that information to the doctor would be retarded. You wouldn't want to provide information to your doctor if your doctor was going to go out and tell the world about it. So that is a productive information flow. That information, about the symptoms that you have, the condition, that you have some symptoms, but you don't know what you have, you don't know how to treat it. Who knows that? The doctor. So we want that information to flow from your brain to the doctor's brain so the doctor can figure it out. That's the economic view of a social benefit to privacy, is that by allowing you to have control over that information, you'll actually have incentives to reveal it in the first place. And revealing that information we think is socially productive. That's an example of a dynamic benefit. But there are also social costs to privacy, right? So there are benefits. We get benefits as humans. There are social benefits in the sense of creating incentives for productive information flows. But there are also social costs to privacy. So there's a strategic benefit. This idea of you want to conceal your true type in order to get a gain. What do I mean by that? If you have, say, a gambling problem or a drug problem, is that the first thing you put on your resume when you go and talk to your prospective employer? Probably not, right? But if you're a prospective employer, you may want to know about that. We have in the United States, there's a big policy issue called ban the box. It's the ability, it has to do with a prospective employer being able to ask an employee about their criminal record. And the idea is, well, we want to allow former prisoners to come back into society and become productive members of society by getting a job. However, if you're an employer, you may want to know if your prospective employee, actually was in jail for something, right? That provides you information. So by concealing that, maybe you as someone who has bad information, you want to conceal that. And by concealing that, we end up with what we can, in economics, we call this adverse selection, where we have a pooling equilibrium, where all we know, where it's hard to tell the good types from the bad types. So you as a counterparty, you as the employer, for instance, have a hard time. You're not allowed to ask if you are a criminal or not a criminal. So then you have to make subjective judgments as to, here's the average criminal rate in the population. So you don't make fine judgments, you make broad judgments. And what happens is you end up having a less efficient market, which can lead to lower wages. It can lead to less employment. That's an example in the labor market, but you can end up in the same instance in credit markets and other places like that. So adverse selection is a big problem with concealing private information. So without private information, markets don't work nearly as efficient. Nearly as efficiently. So there's also this idea in the online ecosystem is that there's reduced revenue for the ad-supported internet. So I'm looking here at my slides. It says ad empirics. I see that my most current up-to-date slides did not quite make it through the system. I'll blame that on somebody else. I'll blame that on me. So the idea here is that without those beneficial information flows that provides the income for for the ad-supported internet, we may not have the free things that we enjoy, right? And there's a lot of empirical evidence. Some empirical evidence, the bulk of it suggests that using information to target ads leads to much higher revenue, which leads to higher content. I've actually done some of that work some of the work myself. So these are some social costs to privacy. So what are the empirical works? Here's some of the empirical work that's there. So, for instance, Amalia Miller and Catherine Tucker have an important paper that, again, published in the Journal of Political Economy that shows how state privacy regulation in the United States leads to less adoption of what are called electronic health records. The use of, rather than just the old-fashioned doctor writing down notes and putting them into a file, actually using the digital technology to take notes. So if you go to an emergency room 100 miles away from your doctor, the emergency room can just look it up in a computer real quick and see what sort of pre-existing conditions you have and treat you, those sort of things. The state privacy laws retard the adoption of electronic medical records and actually lead to worse health outcomes, as you could imagine, for the reasons we talked about. A recent paper published in the Journal of Marketing Science by Gia, Jin, and Wagman finds that GDPR reduces investment in European startups because of the high compliance costs and because of the reduced on the revenue side. So there are cost drivers and revenue drivers, but there's a large statistically significant drop-off compared to their non-European and especially U.S. counterparts as a result of GDPR. Other work kind of goes more at the micro level, again, using GDPR as a natural experiment. Jansen et al. Study the GDPR as a natural experiment and find that there's been a huge, they call it the lost generation of apps. And, who knows, maybe that's a good thing, that there are fewer apps in the Android App Store. But what they find is because of, the reduced ability to monetize, apps are 99% of apps are free, and they're free because they're ad-supported. if you can use less data, less cross-app and cross-site tracking, which the GDPR makes harder, then you get less revenue. So at the margin, less apps enter. And so what they find is they find a lot of exit, and they find lack of entry. And they put that together with some nice econometric modeling and estimate a 32% reduction in consumer surplus, which is an economic term of how well off consumers are in a market. And they find that, you know, that there's a reduction of surplus there. Here's some work that I talked with Garrett Johnson and Tesseri Lin that I've done. They're from Boston University. That COPPA enforcement, COPPA is the Children's Online Privacy Protection Act. It's something specific to the United States that has to do with how we protect the ability of online firms to get child data. It was originally set up in order to prevent sort of stalking and these sort of creepy things, or kids being tricked into giving their parents credit card numbers, things like that. But it has also morphed in to not allowing for what's called child-directed or kid-directed program to be able to do cross-site tracking and behavioral targeting. And so the FTC sued YouTube in 2000, I think the settlement was in 2019, and said you can no longer do behavioral, COPPA says you can't do behavioral targeting to made-for-kids programming. And so what we do is we measure the impact of that on the content. So the idea is the revenue has dried up somewhere between 3 and 10 times for kids creators because they can't use targeting anymore. It's all contextual on YouTube. So the revenue's dried up, and what we find is at least a 10% reduction in child content. Now again, we don't, you know, is that a good thing or a bad thing? It wasn't the idea of the law. The idea of the law is to protect children's privacy, and that's very important. What happened because of the law, though, is there's less content out there, and something that, again, the Janssen paper, our paper it's a working paper now. We'll eventually get to it, though. Is you know, to what extent does that reduce consumer surplus? If quantity goes down and demand curves slope negatively, when you reduce quantity, you reduce consumer surplus. That is a loss. It has to be traded off against the gains to privacy. This is the economic approach to privacy. I will skip the economics in the interest of time. Again, the slideshow that you can. I'm happy to talk about this in the break if you want that. But the summary of it here, in the interest of time, is that firms' incentives to supply. So if you just work through sort of the simple economics of it, firms' incentives to supply privacy, they're aligned with consumers and society. If they can credibly convey their privacy policies and commit to adherence. Now, those are big ifs, right? So what happens is a firm will fully internalize their privacy costs through a reduction in demand. So if I am going to take a lot of data from you and that's going to reduce, and you find that intrusive, then that's going to reduce the demand. The height of the demand curve is the willingness to pay, or the marginal value. It's going to reduce that. And so that reduction is going to play off against any monetary gains, revenue gains that I get. And so what you end up with is that the firm is going to engage in what we call the optimal level of data collection and use. But there we go. I knew that was coming next. But this relies on, again, I'll skip this. This all relies on the idea, you can, for those of you who are studying economics here, this may make sense to you. If not, again, I'm happy to talk about it more in the break. But the outer demand curve is maybe what the consumers perceive, but what if they don't have full information about the harm that they may be suffering from the data collection, then, or if firms cannot credibly convince them, this is a lemons market. This is George Akerlof, famous economist, the market for lemons. You know, if information asymmetries are so high that firms, even if they want to engage in good privacy practices because they think that will get them more customers, if you as a customer say, you can say that all you want, but as soon as you collect my data, I have no idea. I don't understand the online ecosystem, so I don't believe you. I think that you're going to do the bad thing, and it doesn't matter how much you tell me, I'm always going to think you're going to do the bad thing. That's called cheap talk in economics. That's what we call it, and if you can't convey that, then what you can end up with is an equilibrium where consumers always assume that firms are going to be not are going to engage in more data harvesting than they're promising. And so that's the equilibrium that we're gonna live in. So the question is, from a regulator standpoint, is you have to think, what do consumers want? So we like to think the market works. As an economist, I'd like to usually the market is the best way to allocate resources. But there may be reasons to think the market might not fully perform that function. So how do we go about this? So what do consumers want? And this is something called the privacy paradox that is, for those legal academics and economists who study privacy policy, this is a big thing. So if you take surveys, and I'm sure there are some in the EU, I'm focusing again on the United States, that you find that consumers say that online privacy is very, very important to them. 81% say that the privacy, these are very recent polls from the United States. 81% of consumers say that privacy risks associated with companies' data collection outweighs the benefits. 91% say they've lost control. 86% say they've taken steps to mask their footprints. So this is what the survey data says. But when you go out and you actually see what people do in real world, and when economists do experiments, you find something quite different. Okay, and this is what we call the paradox, is the consumers say they really love privacy, but when we try to measure, again, as economists, we always like to measure something called willingness to pay or willingness to accept. This means when you actually have to put your money where your mouth is, as opposed to just say, how much do you like something in a survey, what are you willing to pay for it? So here are just some numbers that come out of various economic studies. $2.28 to conceal. This is how much I'm willing to pay to conceal my browsing history. $4.05 to conceal contacts. $1.19 to conceal your current location. This is the value that consumers place on it. A kind of interesting study from Matthew Kugler and Lahore Straholevitz at the University of Chicago. The very last bullet point there. They did this experiment where they took consumers and they looked at different Google privacy policies, Google Gmail privacy policies, real ones, and older ones and ones that are today that talk about the ability to scan, to do automated content analysis of your email to target ads. Right? That's what Google doesn't do that anymore. They used to, and this is when they were doing it. And what they found is even if they sit down and these consumers have a very long time to understand and comprehend these policies, they understand what's happening. They say, yeah, I think this is intrusive, but I agree that I signed up for this, and it's a trade I'm willing to make. This is what the consumers are saying. That 2/3 would pay, even after knowing everything that Google does, they pay $0 for a version of Gmail that didn't do that. So they're not willing to pay for it. They agree that it's intrusive, but they're not willing to pay to stop it. Nothing wrong with that. And then the 1/3 who said they would pay something, the median price was $15 a year. So not an astronomical amount. So here's just some other studies. Garrett Johnson and other authors, you can opt out of ads. They got a great data set from an online ad server. 0.23%, that's not 23%, that's less than 1% of ad impressions are served on opt-out users. You look at the cookie, when a user comes to a website, that data gets sent out through the supply-side server to the ad exchange. They were able to look and see what sort of cookies were coming with that user ID, and you could see an opt-out cookie. So 0.23% of website visitors use an opt-out cookie. You can do that. The CCPA is the California privacy law recently enacted. There's not a lot of data, but the early data from the suggests that something like 1 to 5% are using the opt-out. So in the United States, if you're at least a California-based website, and that's every website really, you have a big banner that says "Don't sell my data." Well, 1 to 5% of people seem to be clicking onto that. Here, by the way, just some data. There's Google, there's DuckDuckGo. I don't know if you all are familiar with DuckDuckGo. That's the privacy protective, right? So DuckDuckGo, at least in the United States, has spent millions and millions and millions of dollars in advertising. They have ads on TV all the time. They run an ad during the Super Bowl. They have billboards. it's a bad investment, because guess what? Their market share has really been stuck about there. This is Facebook. That's the Cambridge Analytica scandal, biggest privacy scandal in history. You can see that Facebook use dropped off the face of the earth after that, right? Not right. So this is what the polls say. We're all going to take a break from Facebook. We're all going to drop Facebook. That's what reality says, okay? No one dropped Facebook. So what drives the privacy paradox? And this is where it kind of gets into into regulation. So one argument, one possible explanation, and I'm as an economist, I think I'm partial to this in some ways, is it's just rational choice. The privacy paradox meaning when I give you a survey, you say privacy is very important, but I make you make that's called stated preference in economics. Then you have to do revealed preference, which is when you have to make a trade-off against your budget constraint. I have to trade something off. I can either buy email or I can get it for free. I can either pay for this app or I can get it for free. Those are trade-offs you have to make in the real world. Then you end up with making a rational choice. You can love privacy, but the thing is we love lots of things and we make trade-offs at the margin. That's what economics is all about. We have we have opportunity cost of choices we make. And so we make trade-offs at the margin. There's nothing paradoxical about the fact that a survey says, I love privacy, but it turns out that people are willing to make trades at the other side. Another way that this may be rational, there's recent work from Eric Brynjolfsson, a very famous economist in the US, and others that use various methods of measuring value and have found that the consumer surplus generated by these free online platforms is astronomical. You can measure willingness to pay, and you can and that's important because they're all price zero, so they don't show up in GDP numbers. That's another issue. So he was saying, look, we don't use answering machines anymore. There are a lot of things we don't use. We use all this free stuff online, and so that actually looks like GDP's gone down when really GDP's gone up. So they've gone out and tried to measure consumer surplus from social media, from search, from maps, from all the free stuff that we get is astronomical in the trillions of dollars. So you look at that, maybe we value privacy high, but we're making a trade-off at the margin for something we value very highly too, right? So it can all fit into the rational choice model. Another possible explanation for this is that the surveys often ask broad questions. Do you like privacy or not? Okay, we all like privacy, but when you're actually looking at the choice to engage in an app or not, you're often then thinking about a very specific context. You're making a judgment of saying, okay, I'm going to say yes to this app. I'm going to provide them my email address. They may link that up with my Google other information, and I think there may be some privacy risk to that, but I'm going to take that risk for this app right now. It's a very specific context. So it's the idea that the surveys are asking a different question than revealed preference. So that's other. There's also asymmetric information and cognitive biases, right? It's clear that there's a lot going on in this ecosystem that consumers don't understand. It's highly complex. I've been studying it for a long time. I don't know if I completely understand what happens through supply-side servers, ad exchange, demand servers, data brokers. It's a complex ecosystem. So there clearly is asymmetric information, and query whether it's an experience good or a credence good. So it's unclear. There are also cognitive biases that have been well documented in the behavioral economics field. Alessandro Acquisti, who's, if you've studied this field, he's at Carnegie Mellon, one of the leading scholars in this area. He's done a lot in kind of the economics and behavioral economics of privacy, and there's a lot of experimental evidence that suggests clearly consumers can't comprehend future costs. At the same time, they may not be able to understand future benefits. Privacy choices, he's done a lot of work to show that privacy choices, again, are highly context dependent, and it depends on how it's framed. So all the sort of things, those of you who are familiar with behavioral economics, of course, applies here as well, that consumers, we're frail. Our minds aren't really that good. We don't work that well. So what this comes down to is that the job of the privacy regulator is hard. So, on one hand, you say, is the market failing to provide privacy that consumers want? You look at the surveys, you may say that. Then you look at all the revealed preference evidence and say, well, there are surveys, but then there's revealed preference, and then there's what happens in the real world. Is that more representative? And then you have to think, if any solution I could come up with, and this is the very important step in regulation that I think often gets missed, is that there's always an option to do nothing. I know I've been a regulator. I know that when Congress is telling you gas prices are too high, why is that? You've got to do something. There's always the appearance that you have to be doing something. I get that as a regulator, but often the step that is missed is that doing something can be worse than doing nothing, right? That's the Hippocratic Oath, first do no harm. And I think regulators forget that, and I understand, again, having spent over a decade at the FTC, I completely understand the pressure of the regulator to at least appear as if they're doing something, even if they think that really there's nothing to be done here, or anything I can do is probably going to make things worse. But that's something to always worry about. So how does currently the FTC is the biggest is the privacy entity in the United States. Now, currently, it has a rule. It's thinking about doing a rule which would somehow mimic a lot of the GDPR. So that's under consideration now. Happy to talk about that in the Q&A. But what I'm going to talk about is, what I want to mention is how they actually approach it now. So the FTC has Section 5. And Section 5 is prohibits unfair and deceptive acts and practices. So the FTC has used this power. If you lie about what you're going to do with consumer data, that is a violation of the FTC, and that's been primarily what they've done. If you've lied and said, I'm not going to use your data to target ads, or if I'm not going to collect this certain type of data, but you actually do, that is a lie. The FTC can sue you for that. Engaging in an unfair practice, the unfairness prong of the FTC Act is basically a cost-benefit test, where they say, is the harm greater than the benefit? There's a specific statutory language, but that's been rarely used, and only in sort of secret surveillance in the home. So a laptop that turns on its camera and watches you in your bedroom and doesn't reveal that to consumers. That's the kind of case that they've looked at. There's also what I would say, if the first one's a liability rule, for those of you who are familiar with COS and property rights, that if one's a liability rule, meaning we'll go after you when you cause harm and make you pay for the harm you caused, the other is a property rule where the consumer is given the right to consent. So there are a lot of laws that have what we have sort of a notice, consent, correction, and deletion rights in various. That's the idea that you have to say, here's what I'm going to do with the data. Here's what I'm going to do with it. You have to say you're consenting to it. If you are allowed to go in and correct the data, and if you don't like, you can delete it. Now, different laws most of them have notice consent. Correction and deletion is limited in some areas. So we have a lot of laws where we have what's called opt-in consent, which is like the GDPR, where the default is the consumer. You can't collect the data unless the consumer provides affirmative express consent is the rule. These are the COPPA's the children's one, FERPA's for schools, GDPR, you guys know about that. That's not in the U.S., but HIPAA, do not call. Those are all opt-in in the United States. HIPAA's health, do not call is telemarketing. We also have a lot of opt-out, where the default is you can collect the data unless the consumer says no. We have Graham-Leach-Bliley. We have the CCPA, which is the Don't Sell My Data that I already talked about. And then we have deletion rights in some statutes. That's where this idea of sort of the right to be forgotten, which I know is here in the U.S., or I'm sorry, in the EU. We don't have that in the U.S., and we probably never will, but California is considering this in their new California privacy law, something like the right to be forgotten. In COPPA and FERPA and various state student privacy laws, we also have the ability to go in and say, that's not right, delete it, that's not right, delete it. So it all has to do with whether it's correct or not. You don't have a right to delete things you don't like, but you get to at least kind of go in and correct things. So one of the things I wanted to touch on here is, I think, again, a core difference is in the United States, we have the First Amendment. The First Amendment is all about protecting the free flow of information. At the same time, we have no constitutional right to privacy. We have some rights vis-a-vis the government, but those only have to do, in fact, more with reproduction and sort of family, privacy from what you do in the sphere of your own home, from government intervention, but not have anything to do with information flows, okay? And so we don't have a constitutional right to privacy, but we do have a constitutional right to the free flow of information. And how has that been interpreted? Going back to 1976, kind of a landmark case of the United States, Virginia Board of Pharmacy, where it had to do with a Virginia law that prohibited drugstores from advertising price, and the Supreme Court said that before that, it was thought that the First Amendment in the United States only applied to sort of the press or to very political action. You know, the state can't stop you from saying bad things about the president or protesting a war or something like that. But it didn't apply to commercial speech meaning an advertisement. This case said, no, it actually applies to that too. And I put this quote up there because the reasoning is that, you know, yes, there's all this urgent political debate, and we hear, you know, that's but for most consumers in their day-to-day action, knowing about allowing advertisements that allow them to know about the price of goods and services is actually a lot more important than a lot of the things that are going on at Capitol Hill and the State House, right? So if we're allow the government to repress that, then that actually violates the First Amendment right of the consumer. This isn't about the firms having the right to speak. This is about consumers having the right to hear. I'm allowed to hear about marketplace information because that's going to help me in my life. This is morphed into what's called the Central Hudson test, where before speech is protected, it has to go through the government. The burden is on the government to show these steps. First, they can regulate deceptive speech or speech concerning an illegal activity, but if it's not, falls into one of those bins, the government then has to say that I have a substantial government interest in this. Does the regulation advance this interest? That means, is there a causal nexus? And that's a very stringent. The Supreme Court, you can't just say, oh yeah, these are related. You have to come in with evidence to show that my restriction is actually going to further my need, and is the restriction more extensive than necessary? Are there less restrictive alternatives? It's very much like the rule of reason in competition law in the United States. It's not surprising because these came up about the same time in the same court. There are various, I won't, in the interest of time, we have various privacy regulations. You know, does it impermissibly burden speech? It depends if it's opt-in or opt-out. I think if it's opt-in, the answer is yes. And then we sort of have, okay, I'm going to go through this very quickly without going. It was actually a lot of work to make this slide, but this is the last word in the Supreme Court, and it has to do with the restriction of speech in the commercial prescribing context, and it had to do with a Vermont law that kept CVS, as a big drugstore in the United States, it kept drugstores from telling pharmaceutical firms about prescribing practices, so pharmaceutical firms could then use that information to market drugs. It allowed everybody else to use it, but it didn't allow the firm to use it. So the Supreme Court said that basically collecting data is protected by the First Amendment. All right, so that's kind of where we are in the First Amendment. So, Martin, how much time am I basically? 5 minutes. Okay, good. Okay, so the last thing I'll talk about here is just, well, if we're thinking about privacy regulation, the First Amendment's going to put up really large roadblocks on any privacy regulation. So that's something to stay tuned. In the United States, there's a privacy bill being considered. We'll see. We're obviously having a big election. It's in the news. We'll see where things stand. There's always been a big privacy bill that's been about to be passed since I can remember. So this is the furthest it's gotten. It's been reported out of committee. We'll see. The FTC, of course, is doing its rulemaking. Even if it goes through, that's a very long process. And they'll all be subject to First Amendment challenges. I will guarantee you that, because for the reasons I said, the Sorrell case really suggests that there is a protection both on the advertising side, but collecting the data that is necessary to advertise can also be protected speech as well. So competition is a solution. So that's often seen. The idea here is that firms compete on privacy and that there's conduct that reduces competition that can then a causal link between I'm not competing, there's a merger, the firms used to compete, now they don't compete as vigorously, so they're going to offer less competition. That's a theory that used to be just in academics. It was employed to some extent, or is currently being employed in the Bundeskartell decision, or I guess case against Facebook right now. It's very focusing on competition and privacy, but now it's sort of seeped into the United States as well. This is the most recent DOJ case against Google about some of the harms, maybe a reduction in privacy. The FTC versus Facebook case again, that this lack of competition from Facebook may reduce privacy. This is necessary because if you're going to go after these competition platforms, what's the price they charge? They charge zero. So you can't look at higher prices. What's happened to output? Well, output just keeps growing, right? And so you can't say output's down. So you have to rely on some sort of non-price metric, and privacy is one of those non-price metrics. So some issues to consider, and in my limited time here, I'll just go through these fairly quickly, but I'll direct you to some research that I've done with Professor John Yoon, my colleague, who will actually be here tomorrow, on these topics. Right, we have a nice paper that I'm sure I'll get Martin to send out to all of you to push up my SSRN citations. So issues to consider. The idea that you'll take more, this idea that data is price. We hear this, data is the new oil, data is price. If you're not the subject, if you're not the customer, then you're the product, right? So if we think that data is the price, if they're extracting more data, one question, kind of a fundamental question to ask, is we kind of assume it's consumer data, but much of this data is cross-site or cross-app tracking that has to do with your interaction with somebody else's server. So when you go to Google or you go to, say, the New York Times and you click on different stories and different ads, who actually owns that? You're interacting with somebody else. Is that actually your data? The fact that you clicked on the most recent college football ranking to show that you're a college football fan, or does that belong to the New York Times, or does that belong to the third-party analytics firm that the New York Times allowed to track? Right. So that's a question you have to ask. From an economist, and this is actually somewhat of an esoteric point, but the idea that if we think of privacy as, say, a dimension of quality, the monopoly provision of quality there's no fundamental theorem in economics that says that an economist, especially a platform economist, is going to provide less quality than a competitive market. It's a theorem put out by Michael Spence, who eventually won a Nobel Prize, not just for that work, but from a lot of other work. And then it's sort of magnified if you put it into a platform setting where you're actually trading off platform, two-sided platform. You've got consumers on one side, you've got advertisers on another, and you may have publishers on a third side. Multi-sided platform, it's a delicate balancing act. So there's no theorem that says that there's going to be a monopoly provision of quality. There's a more important question, too. How does the level of competition impact privacy? So do consumers respond to changes in privacy? We just talked about the privacy paradox. It doesn't seem that they do, right? Number one, there's not a lot of competition over privacy, and the little bit that we see doesn't seem to be very effective. All right, so we don't see that being a super important metric of competition. So if you stop, or is that really something, is that really a core area of antitrust concern? If there are a lot of competition over privacy, even with the big tech platforms, it doesn't appear that to necessarily be the case. There's something that I call, in my paper, called the underpants gnomes problem. That's a reference to South Park, another great U.S. institution. For those of you who are not familiar with it, again, I'll reference that in my paper. Is this idea that it's one thing to say that a firm with market power reduces its quality and then holds its price constant. So the car maker becomes a monopolist and sells you the same car for $20,000, but gives you a worse set of tires. Consumers are unambiguously worse off because they're paying the same price for a lower quality good, right? The same, but if for the platform, for that analogy to go through, the platform becomes a monopolist, two firms merge, they offer less data protection. Well, they take more data, right? But it's unlike giving you a worse set of tires. You take more data. That data all exists on a server now. So I've spent more money. I've got this data. The only reason I take more data is I need to monetize it. How does a firm monetize data? Well, they monetize it by, most of the monetization happens through, at the end of the day, trying to advertise, right? Trying to sell something. So there's always an intrinsic benefit on the other side of that that has to be netted out. The point is that it's much more complicated. It has to do with the demand for privacy. It has to do with the demand for the underlying product, and it has to do with the correlation between the two of them. It's a very complicated economic problem. Again, if you get into the nuance, the analogy of price and quality doesn't come through. And then there's finally the problem of subjectivity, and I'll leave it at that, is that when a regulator has to decide as, I'm not looking at price and output as the dimension of quality, or I'm sorry, as the dimension of competition, those are fairly easy measures. Did output go down by 10%? Did price go up by 10%? I can measure that. How do I tell if privacy went down or up? The problem is privacy can go down, meaning I say I collect more data, but what happens on the back end? I perhaps offer a better, richer product that has more customization. I can monetize it better with ads. It's free now as opposed to behind a paywall. Some people benefit, some don't. It's complicated, and it calls for more subjectivity, which makes the world harder for businesses. Bright line rules are good for businesses. Subjectivity in the hands of the regulator is bad for businesses. So these are all issues you need to consider. I'll leave it here. I have about 30 more slides, but I'm not going to go through them. Just kidding. Anyway, but thank you.
Thank you very much, James, for this very interesting lecture, inspiring for both the data protection and competition law panels. And now we're approaching Europe, as well as we're approaching content regulation. You have the floor, Balázs.
Thank you very much. It's never easy task to follow a native English speaker. I do my best and hope you get used to my horrible English accent very quick. So I wanted to make a bridge between our two presentations because I thought you will reach the point when you will speak about the
Unfortunately, I ran out of time.
The 230 of the Communications Decency Act.
Yes, so I'll let you.
But you wanted.
What?
We can confirm you wanted to talk about the Communications
I
Decency
did want to talk about that, but as a professor, I have the problem of you give me a podium and I'll go on forever.
Okay, so as making a bridge between the two presentations, I will start with the US content regulation. Very brief overview. So the goal of my presentation is in the first panel, we have many students here, so it's giving a general overview of regulatory environment of online platforms in the United States and more in Europe. In Europe, I will focus on national initiatives and then on the European Union side, at the European level regulatory environment. So as far as the US is concerned, so the first ancient pillar of content regulation is the Communications Decency Act dating back to '96. Which gives quasi-immunity from responsibility for online platforms because it says that they are not considered as publisher of the content if the content is published by a third party, and civil liability, that's the most important thing, that they can moderate content until they do that in good faith. Or this is the so-called Good Samaritan clause. This clause has become a bit obsolete in the recent times. That's why we have so much regulatory initiatives in the United States at this time. The other legal act we have to mention is the Digital Millennium Copyright Act, which deals with the copyright infringements and gives immunity as well for the online platforms. I lost my presentation. Yeah, I got it back. Thank you. So it's 98. And now we have a lot of proposals coming from, for example, the President of the United States from 2020, I think, yes, May 2020, because Donald Trump considered that the platforms abused the Communication Decency Act, Article 230, so he instructed all the public authorities to interpret very narrowly the application of the Communications Decency Act, not to allow the platforms to moderate the content on political basis. That was the assumption of Donald Trump. Then 2021, May, we have a new bill proposal for the Congress. It's Safeguarding Against Fraud, Exploitation, Threats, Extremism, Consumer Harms Act. It's from the other side. It intends from the Democrats to widen the exceptions under this Communications Decency Act to allow a larger possibility for the platforms to moderate content. Because, for example, it was inspired from Donald Trump, the tweets of Donald Trump, which according to some, led to the siege of the Capitol. Then we have to mention the competition law proposal, which wanted to make easier the switch between the platforms. Because according to network effects, it's very difficult to switch or to question the dominance of Facebook or Google, for example, because of these network effects. So they wanted the platform to have interfaces where for example, the data portability could be possible among different platforms. Then 2018, February, the so-called Cloud Act. It was because there were mutual legal assistance treaties between third countries. Why? Because the platforms often have data which is necessary for criminal investigations in third countries, and to have this data, it's very difficult and demanding process to have this data from the United States servers, for example. So this would make it easier to have this data and make it clearer for the platforms what do they have to do, to which country they can give the data. Then one very interesting proposal, it comes from Texas. It's a more Republican proposal. It wanted to ban basically Facebook and Twitter and all these platforms to moderate the content. They introduced a bill, which is a more general bill on transparency of the platforms, on complaint mechanism. It's nothing special. It's like the Digital Services Act in the European Union. However, it has a very specific provision, which you can see in section 14. 3A, which says that, basically it says that the platform doesn't have any right to censor or moderate the content, for example, not to be implicated in political speech, for example, not to be able to moderate the political speech of Donald Trump. So what happened, what the aftermath of this bill, is that at the first level, the first instance, it was upheld. No, it was refused by the Fifth Circuit. That was the first level, and that one. Then the appeal, Court of Appeal, upheld not the decision, but it said that it's in line with the Constitution of the USA. So the act can take effect. And then 3 days later, the Supreme Court said that no, it cannot take effect. So it's an ongoing legal debate. What will happen with this act? Then we have an act proposal from 2022, which said social media platforms could be sued because the children became addictive of social media usage. That's a very interesting proposal as well. I'm very interested if it will take effect or not, or if can it be effective. How do you prove that your child became addicted because of the social media platform? So really, as I mentioned, very brief overview of the USA, and more details about the European regulatory environment. So first of all, national initiatives. We have some. The first one from Germany. So from Germany, between 2017, there was an article of the Süddeutsche Zeitung, which revealed the practice of the moderating practice of the Facebook. For example, how these 200 moderators in Germany worked, under what conditions, and that's put the spotlight on the practices of Facebook, how it's untransparent, and it started to worry the legislators of Germany as well. That is underlined by another article from The Guardian, which revealed more generally about the practice of Facebook. So as a reaction, we had this Network Enforcement Act, the NetzDG, if I remember correctly. It was adopted in 2017. The main rules are that platforms having more than 2 million users are obliged by this law. It defines the illegal content. It's very important because in Germany, it's not the platform who can decide what's illegal and what's legal, but it is set in the law that what's legal and what's illegal. So it tries to eliminate this so-called pseudo-legal system, which there is a legal system adopted by the Facebook and there is a legal system adopted by the sovereign state, in the case of Germany. Sanctions can from 500,000 euros to 40 million euros. They have to make transparency report, and there is a regulated removal process. There was one major fine for Facebook, for example, 2 million euros, because Facebook embedded the complaint system foreseen by the law, but you have to click, if I do remember well, 7 times. But if you wanted to make the complaint, use the complaint system of Facebook, you had to click only once. So, of course, everybody went through the complaint system of Facebook, so they were fined 2 million euros. And in Germany, they have adopted as well a Network Enforcement Act, the guidelines for the transparency reports. The second country is Austria. Austria, we find 3 laws. The first one is the Hass im Netz, Hate in Network, Fight Against Hate Act from 2020. It's not just a law like the network law from Germany. It has modified 10 different laws. For example, the Criminal Procedure Act, and one of the famous modification was the so-called mandate process. So the judge can order the imminent cancellation of illegal content. The second one is the so-called Kommunikationsplattformengesetz, so it's a communications platform law. It's very similar to the German national law, but the difference is the communication platforms have a lower threshold to become regulated by this network. And there is one regulation adopted by the media authority, the communications authority. This is Transparenzberichte. It's more about the details of how the platforms have to be transparent, how they have to prepare the transparency reports. Poland, a very controversial act. So Poland proposed a social media free speech law. So every platforms which have above 1 million users in Poland are covered by this law. The law creates the Freedom of Speech Council. The platforms have to make biannual reports if they have more than 100 complaints a year. It is still not adopted. I think the adoption was suspended because of the DSA, which has just taken effect or will take effect in 1 week, and then they will see what remains as a possibility to legislate. France. In France, there is no specific legislation. There are rules, of course. For example, the law on the confidence in the digital economy. But they had a very interesting proposal. This is Law Avia, it's called, the Avia law. This is Madame Avia, Laetitia Avia, who proposed this act. Why it was interesting? Because for certain crimes, they foresaw that in 1 hour, the content has to be removed by the platform. The platform was to decide what is terrorism, what is the content in favor of terrorism or child pornography. And for other serious crime defined by this proposal, the platforms had 24 hours. And again, effective notification system, the media authority are entitled to create specified rules, and NGOs are designated of child protection to to initiate removal, for example. What is very interesting is the two rules above, so 1 hour and 24 hours, because it provoked criticism from many NGOs saying that it will kill freedom of speech in France, because in 24 hours, the platform has 1 hour, they will cancel everything basically which is signaled to the platform, and it will endanger the freedom of speech. So there was a decision of the Constitutional Court in 2020. In June, it said that it's not constitutional because the platform doesn't have enough knowledge, doesn't have enough time to decide, and there is no enough guarantees that the judge can oversee that ruling from the platform. So it's not constitutional, so it was aborted. The UK, because we are not just European Union, when I talk about Europe, I talk about the UK as well. So the UK has adopted an online, not adopted, it's a proposal if I remember right, it's an online safety bill. Why it's interesting? Because it's pretty different from the European approach. It was presented in March 2022. It has an ambition to cover all aspects of online content. It's a bill of 213 pages. There are two types of services, the user-to-user services and the search engine services. Ofcom, which is a regulator for telecommunications and media, among other things, are entitled to define the detailed rules. And I will come back to that later on, which are the mistakes or empty places of missed places of the DSA, because this bill was talking about the public life and public speech, importance of public speech content, for example, how these platforms can contribute to the public debate, for example, which is not dealt in the Digital Services Act. And then a few words about Hungary, because the Minister of Justice has established, if I do remember, in 2020, during the COVID commission, I still remember, even if I not see it, if I don't see it, the Digital Freedom Commission. Its aim was to analyze the situation and make proposals for regulation at national level. It has even published a white book in 2021, but finally it has suspended its work, I do believe, because of the adoption of the Digital Services Act. So we have to see what is well regulated in the frame of the Digital Services Act, and then if we have any problems, we can regulate at national level, but this is not the time to go further on the issue. And European Union level, so just to show you the macro environment, because we have social media platforms and platforms in general, and do not believe that the Digital Services Act and the Digital Markets Act are the first acts which regulates the online platforms. Already the Electronic Commerce Directive, which is very obsolete and will be replaced by these new acts, they didn't think that they will regulate this question, but they regulate it in an obsolete way. But beyond that, we have many acts. So for example, just to mention the GDPR, right to be forgotten, profiling, the Audiovisual Media Service Directive regulates, since 2018, if I remember correctly, all the video sharing platforms, for example. Then we have Telecom Single Market, the network neutrality. We have e-privacy directive. We have the Digital Data Act. We have the Digital Data Governance Act. We have the AI regulation proposal. We have child sexual abuse material proposal. We have terrorist content regulation. We have network security regulation, all affecting these platforms. And finally, we have these new ones, the Digital Markets Act. I will not enter into detail regarding to that. It's more about competition and market questions, because these platforms have become, at least in Europe, that's for sure, monopolies. So how to avoid that they abuse this monopoly in the European markets, and our famous Digital Services Act. So this under construction science shows how it's an ongoing work within the European Union, how many new regulations will be adopted very soon. So if you take a look at the scope of the Digital Services Act, do not think that it's just about the social media platforms. It's about a lot of services. If you take a closer look, you can see, and with red, the online platforms and the search engines. There are four major, so the umbrella notion is the intermediary service. Then we have transmission services. I will not explain all the notions and all the services because it's not important. It's important, but it's not in the scope of my presentation. So network services, domain services, over-the-top services. We have the cache services, the content delivery network, proxy, content of other cache services. We have the search services. Within the search services, we have the search engines, which are under the scope of the Digital Services Act, and voice assistant services as well. And finally, we have the hosting services. And within the hosting services, we find, beyond cloud services, internet hosting, paid reference, online file hosting services, the online platforms. And what kind of online platforms we have? We have social media platforms, regular and very large online platforms. Very large online platforms are the online platforms we have, which have more than 45 million users within the European Union. And we have video sharing platforms and online marketplaces like app stores, accommodation, like, how's it called? Accommodation, travel, yeah, booking, thank you. And I don't travel a lot, unfortunately. And transport applications such as Uber, Bolt, and platforms like this. So just to say a few words about the Digital Services Act, I will not enter into details because it's a huge act, a lot of questions. I think there are more questions how it will be applied than responses and answers. The main goal of the Digital Services Act is to create a safer digital space where fundamental rights of users are protected. Very well. And the main principle of the DSA is what is illegal offline must be illegal online. That's what we saw, if you remember, in the German Act as well, that they have specified what's illegal. It's not to Facebook or Twitter or any other platforms to decide what's illegal. About the schedule, where we are now, so in 6 days, the Digital Services Act will take effect. It's a regulation, so it will be mandatory in Hungary as well. Then next spring, I think, so the very large online platforms and the very large online search engines which have more obligations will be designated by the European Commission. And by February 2024, each member state has to designate digital service coordination authority. So a few questions about the DSA. I'd like to show you one process, for example, which shows how I'm worried about the efficiency of the application of this regulation. So we have a man or woman, Hungarian, who uses Facebook. They have a debate with Facebook, and he makes a complaint under Article 53 of the Digital Services Act. But it says that you can place a complaint at your national, where you live, but then the complaint, where appropriate, should be transmitted to the digital service coordinator of the establishment of the platform. So in case of Facebook, you know where is it? Ireland. Okay, where appropriate, what is appropriate? Who decides what's appropriate? And then, if you feel, as digital service coordinator, appropriate, you can make an opinion. With an opinion, you can transmit this file. So you transmit this file to Dublin. In Dublin, they see that, oh, it's a very large online platform, so I have to transfer it to the European Commission. Once it's at the European Commission says that, yes, but I don't want to deal with that issue. He will retransfer it to Dublin. And we have this poor Hungarian who doesn't know what to do, because at the online sphere, an illegal content or anything which goes wrong with illegal, it's an imminent harm. So it's online, so we don't have time. So my question is, how much time do we have? How long will it take? Because the DSA doesn't foresee any deadline for this procedure. That's a problem, I do believe. Then it doesn't deal at all with fake news. I do know that fake news is a very hot topic and it's a thin ice for lawmakers, because who can decide what's a lie? Is a lie forbidden? Of course not. Holocaust denial, it's a lie, of course. But what is fake news? It's a very political notion, and from lawmaking perspective, it's a very thin ice. So the lawmakers do not want to deal with that issue more in details, but this is one of the major preoccupation of Europeans because of the involvement of these platforms on the spreading of fake news. Child protection. It's not true that this regulation doesn't deal at all with child protection. We have some words in the preamble, and it deals with targeted advertising, but doesn't deal at all with child protection, which is one of the major preoccupations as well vis-à-vis the online platforms. We have to admit as well that there is a new child sexual abuse material proposal, so maybe that will solve this issue. And public speech. The importance of public speech, because these online platforms have become the itinerary of these public and basic ideas where we can make choices about which political party we will choose, for example. Most of the people make their decision about the content they see on Facebook, for example, or what they find on Google. So this is a very important question as well. It's not in the DSA. So what are the next steps? From the European Union side, the European Commission has to adopt guidelines. It will be very useful because there are many things which are very obscure now in the Digital Services Act. At the national side, we have to adapt, if it's necessary, our national legal framework, since it's not directive, it's a regulation. We have to adopt national legal framework. We have to legislate the detailed process and competencies of the Digital Services Coordinator. And we'll see, we have to see if there are any other topics which are not covered by the DSA, but which are a problem with the online platforms, which could be solved at national level. So the National Media and Info Communications Authority has a long history dealing with issues related to online platforms. So, for example, it's in Hungarian, and if I translate it into English, it's Magic Valley, but it sounds very bizarre. Deals with media literacy, online media literacy, so it's a very important topic. Then we have the Internet hotline operated by the authority, which receives several thousand complaints a year. It could be very important dealing with complaints coming from the end users under the DSA. And then the new president we have here with us, András Kotti, decided to create a new department dealing with the online platforms. It's very important because it shows that we try to keep pace with the technology development, not just about telecommunications media, but the online platforms as well. This new department and the authority is conducting in-depth researches in all the areas and preparing for the application of this new regulation. And if everything goes as it's foreseen in this amendment, proposal of amendment of an act of the Hungarian law, the Authority of Media and Info Communications Authority will be designated a digital service coordinator. I do believe that this will be, if it's adopted within 1 or 2 months, it will be the first DSC designated in Europe. And I would not say that we have time until 2024, because next summer the very large online platforms will be already designated. So we don't have much time, we have to be prepared. What are the main tasks of this DSC, Mutual Assistance Cooperation, certifying out-of-court dispute settlement bodies, enforcement and investigatory tests, assessing user complaints, awarding the status of trusted flaggers, and requesting data from very large online platforms and very large online research engines. So to conclude, in my opinion, what are the essential functions of the state? First of all, eliminate the existence of pseudo-legal systems. So it's not okay that we have one legal system adopted by a platform and we have another legal system adopted by the sovereign state. It has to be in line. Second, know your platform. What do we mean by that? The platforms has to be transparent. Of course, it cannot be reached, I do believe, but it has to be as transparent as possible. And the regulators and the state has to know the platforms as well, how they function. It's normal, and we cannot change it, that regulation is always lagging behind the technological development, and it's especially true for high-tech industries. But we have to try, we have to do our best, because if we don't understand the environment, we will never provide assistance and protection for the citizens. And we have to have the ability to protect the users through effective complaint system, not complaint system which takes 4 months. To protect the market competition, the DME might be useful for that, and the competition authority might be competent. And last but not least, the democratic process and public debate, which is on the online platforms more and more. With that, I thank you for your kind attention.
I thank both of our keynote speakers for the very interesting presentations. And you might notice a questions block in the program, but we have run out the clock, and I think we have raised all the questions that we needed to ask in the keynote speeches. So I will encourage everyone to continue these questions and answers over the coffee break, and we meet here again at 2 o'clock to begin our first panel on content moderation. Thank you very much.